I'm Tom Cross, and welcome to Cross Examination. I'm a barrister in London working on cases with cultural, moral and ethical importance. In this podcast, expert panellists join me to take an independent look at the law surrounding one of these issues. At the turn of the millennium, Sierra Leone was still experiencing a brutal civil war, which took the lives of up to 70,000 people and displaced around 2.5 million. One of my guests today, who we're calling Mr. A to protect his privacy, was a child at the time. He was, as a tribunal found, recruited as a child soldier and beaten and tortured by the rebel forces. So he fled and ended up in the UK to claim asylum, but his claim failed. He nevertheless remained in the UK, and earlier this year, nearly a quarter of a century later, he was finally granted settled status following unsuccessful attempts to deport him and repeated periods in immigration detention. So how does UK law deal with persons in Mr. A's position, and how can it take such a very long time? What's the threshold for being able successfully to claim asylum, and what happens when claims succeed or fail? And, now that the Safety of Rwanda bill has passed, how might that legislation affect people like Mr. A in the future? Cross-examining with me today are two of the most expert lawyers in the country practising in the field. Toufique Hossain heads up an award-winning public law team at Duncan Lewis. He's top-ranked in several fields, in both Chambers and Partners and Legal 500, and he recently represented the lead individuals in the landmark Supreme Court case in relation to Rwanda. Roberta Haslam is a partner at Bindmans LLP, who's been practising in immigration since 2007, during which time she's worked on the widest possible range of asylum claims and appeals. Welcome to you both. Roberta, people move from one country to another for all sorts of reasons, work and travel being examples, and immigration law in principle covers the lot, I suppose. But today we're talking about only one type of immigrant, an asylum-seeker. Before we hear the story from Mr. A, let's clear the ground. In law, first of all, what is an asylum seeker?
So an asylum seeker is someone who is outside their country of origin and is seeking protection from risk in their country. They need to meet the definition of the Refugee Convention, Article 1, and there are various factors that they need to meet. They need to show that they are outside their country of origin, that they face a well-founded fear of persecution, and persecution means serious harm, and for that you're looking at torture, death, kind of very significant harm.
Yeah.
They need to show that the reason they face that harm is for one of the Refugee Convention grounds, and these are race, religion, nationality, political opinion, or member of a particular social group. And things like political opinion might be opinions that they actually hold, or opinions that are imputed onto them that they've kind of by others that they're forced, that other people perceive them as hearing.
Is there any difference legally between the expression asylum seeker and refugee? You mentioned the name of the convention at the heart of this, the Refugee Convention. There
is an asylum seeker is a person seeking protection, whereas a refugee is someone who has protection. It's been accepted that they meet that definition, that they require protection. And
this Refugee Convention that you mentioned, I think 1951 Refugee Convention, so going back right to the period kind of post-war, so dealing with the problems of displacement that inevitably happened during the Second World War.
Exactly. It was set up to kind of protect those people who, having seen massive harm through the war, to ensure that people were protected from those abuses that were happening and to ensure it didn't happen again.
Toufique, we hear the expression on the news time and time again of illegal immigrant used in connection specifically with asylum seekers. Is that right legally?
The law is entering without leave is a breach of the Immigration Acts. It constitutes illegal entry as defined by the 71 Immigration Act and can carry criminal sanctions. But the Home Office's own guidance pretty much says that most, if not the vast majority of cases, are managed using administrative powers. Public interest means that they won't be prosecuted. And really, it's not the breaching of immigration rules or committing criminal offences when it goes to the idea, the concept of an illegal immigrant, because that's a phrase which it's not the person that's illegal. That's I guess what the issue is here. Yeah. It's the narrative and the term of the illegal immigrant. I mean, the UN recognises that the majority of undocumented migrants have lost their status due to exploitation or delays in obtaining documents or through war or conflict. that they're not committing an offence by leaving their country or passing through other countries without documentation. I would say that ultimately the term illegal immigrant is oppressive. I think there's history to it as well. It's worth mentioning that the term illegal has been used throughout, the last few centuries when it comes to Quakers or Jesuits or Jewish people fleeing the Holocaust. You've got a long history of that term being used when it's trying to target people that are not particularly well received by the powers at the time.
Roberta, when somebody comes to the UK in order to claim asylum, a process is engaged. What in broad terms is the nature of that process?
So kind of briefly, so people will claim asylum, they'll have to attend what's called a screening interview where they'll set out basic details about their asylum claim and their kind of details, their personal details, family details, medical details, and then a decision will be taken about where to route that person to. There's then opportunities to provide more evidence, to set out other reasons why you should be allowed to remain in the UK, so other human rights grounds, and eventually you'll have a substantive interview. This is the kind of standard process traditionally, and in the substantive interview you set out in much more detail about why you're at risk in your home country. You'd want to be providing supporting evidence to show that risk, and following that you'd get the decision on your case.
Is it possible to generalise about the amount of time that
traditionally, when I first started, it was very much many years ago. They were aiming to deal with them very quickly, and then they hoped to deal with them within 6 months. That's the kind of aim. But actually, we have cases that have been waiting many years for decisions. That's taking longer and longer. They're now trying to kind of cut that down again, but it can be many years before people get a decision sometimes.
And if your claim is refused, you have a right of appeal?
You have a right of appeal. You can get a decision. You have to lodge your appeal within 14 days. That appeals to the first tier tribunal. Mm-hmm. And then there's onward appeals if you can identify an error of law. So if you're successful, then the Home Office is seeking for that, or if you lose and you're looking for an error of law in that determination, then you can seek permission to appeal to the upper tribunal.
And Toufique, in terms of the consequences at that point, either the initial decision by the immigration official or potentially on appeal if you need it, if you're granted asylum, first of all, what's the position? Can you stay indefinitely? Is it time limited?
So it's not indefinite initially. You get 5 years leave. It would be refugee status leave, and then you're eligible for indefinite leave after that period. You can apply for indefinite leave. If your refugee claim fails, you may still be eligible for other forms of leave. One main form of leave is humanitarian protection. That basically is leave for people who, as Roberta said, may not have fallen within the risk categories that the Refugee Convention provides. So you haven't suffered persecution on account of being, a member of a particular race or religion, etc. But you do have, there is a possibility of a real risk of serious harm if you are returned to your home country. So, for example, people fleeing a conflict zone. An example is Iraq's civil war, where asylum seekers were granted humanitarian protection, but not necessarily they were being targeted for their specific ethnicity or their race or their political opinion. And so humanitarian protection is also 5 years. There are some differences in terms of whether you type of travel document you get, but that's still a very serious period of leave.
And if you get your 5 years, insofar as it's possible to generalise, have you got a much better chance of thereafter, after 5 years, getting indefinite leave to remain? Are there many cases, statistically, of those who successfully establish a case for protection then in 5 years' time fail to continue to be entitled to remain?
Usually the route is indefinite leave. There may be some exceptions to that if there's a review of their case for specific reasons. There may be some individualised issues that could the Home Office could have concerns, but generally yes, your route is towards the indefinite leave.
What about if you're not granted asylum? What's the position then? What actually is your immigration status at that point?
So if you're refused asylum and you don't come within the remit of humanitarian protection, there are possibly other forms of leave. There's discretionary leave. There's sort of family leave if you've got strong family life here. There's forms of leave in relation to trafficking victims. If you're an unaccompanied minor, for example, and you don't necessarily fall within the asylum categories, you could potentially get leave on a discretionary basis. But if you don't fall within any of those and your case is refused, then technically, you are liable to be removed from the UK.
And removal's the same thing as deportation for the purposes, or
No, there is a difference, and I think asylum lawyers are always keen to sort of to identify that difference. But I think it does make a difference, because I think deportation, sort of in the media and the press, carries sort of connotation of being a foreign national offender, because in fact deportation regime is very much directed to people with criminal convictions, whereas administrative removal it does very much apply to asylum seekers who have just simply failed in their process.
So it's not the case that just because your asylum claim fails at the last hurdle, you are liable for deportation, but you may well be liable for removal if, as you say, one of the other grounds for leave to remain doesn't apply. Well, it's a feature of discussion on asylum that you hear a lot of viewpoints, opposing viewpoints, of course, about how asylum seekers should be treated, but you don't often hear from those who've been through the asylum process themselves. I spoke to someone we're going to call Mr. A, who started by telling me about the circumstances in which he fled his country, Sierra Leone. Let's have a listen.
I did not really actually choose to come to UK, but because I'm fleeing from the war and the torture that I've been through, and unfortunately I find myself in UK. At a young age, I lost my parents. I left school. I have to be working with her in the farm. You know, it was a very hard time. She was sent to different places and with my little brother, and then I sent to different place, and then since then I never heard them anything again. Of course, I know they've died, and I just been there, tried to survive several times with them until a time came, and then the government so just attacked the rebel camp, and then I was able to escape, and I went through to Freetown, and I got a ship, and I flew away from Sierra Leone. Yeah, I've been tortured, we've been beaten day by day, we've been lashing, we're moving from one camp to another. It's a very tough time. Where we took the ship from Sierra Leone, there was a lot of people in the ship as well, so the ship was going to South Africa, so we met like an agent, so he say, here is dangerous, we might be returned to Sierra Leone and face the same problem, and then some of us have some little diamonds on them, so they give it to them. And they say, okay, we will help you. They become like agents, so they do the rest of the journey until we reach here. They give us some false passport and push us to the airplane because they have some money, and then I found myself here. Yeah, so when we arrived, they checked everything, and then they found that the passport wasn't it's like a kind of false one, so I just told them originally we come from Sierra Leone, and then we claim asylum there. That's what happened. I told them I was captured by the rebels and I tortured. Yeah. I have a lot of scars on my back. They melt. One time they melt. I was trying to escape. They see me. They capture me back, and then they melt plastic. They put hot metal, and they drop plastic on it, and they drop it all over my back. I have the scars. And another time I tried to escape, they captured me, they cut me, my leg, and they injure me, they beat me. I have a lot of wound in my back and my legs. And another time they even pull my teeth. They pull my teeth with a plier. So now I have to put in indenture there. According to Home Office, they said they sent a self-evidence form to my previous lawyers, not Duncan Lewis, to my previous lawyers. And then I did not receive that form to fill in and return it back. So that is the basics. Home Office refused my asylum. They did not believe me. They think either I ignored the self-evidence form, so at that moment there's nothing I can say. And during that time, the appeal failed until 2003 or 4 somewhere. So by then, they say the country is there's no more war. So they think it's safe for me to go. That's what they said.
Toufique, let's talk about evidence. Mr. A is someone who isn't initially believed. How realistic is it to expect someone seeking asylum to come up to proof, to demonstrate to the satisfaction of somebody they've never met before the account that they give?
Yeah, that's quite accurate. I think the starting point is that we remind ourselves what the law says, which is that the standard of proof in theory is actually pretty low. The Home Office has to sort of effectively see whether there is a reasonable degree of likelihood that the person is telling the truth. The terms real risk, real possibility, and the Home Office's own policy and structure on credibility sets out and reminds caseworkers that the standard of proof is low, that they will accept credibility if there's sufficient detail in their story that is consistent and coherent, and that it's consistent with other evidence and it's plausible. So all these terms are sort of suggesting that there's a low standard of proof. But in reality, we see that people like Mr. A and many others, many of our clients, struggle to get through the credibility hoop because I would say there are two big issues. One, there's a culture of disbelief within the Home Office that's been, I would say, systemic and institutionalised through many years. It's worth mentioning Wendy Williams, who was the author of the Windrush Lessons Learned Review, who found that there was a culture of disbelief and carelessness that ran through the Home Office. That was in the context of Windrush. But I would say that very much goes right through the asylum system. The second big issue is the lack of preparation, the lack of access to justice, because a lot of the ways in which an asylum seeker can prove their credibility is through the use of, say, medical experts, country experts. So Mr. A, I mean, he said he had scars on his body. I assume the Home Office either didn't bother checking or didn't have sufficient scarring expert or medical experts to sort of corroborate what he went through.
Roberta, another feature of his case that strikes me as interesting is you have the civil war, in his case in Sierra Leone, that lasts for a particular period of time. He arrives at the UK whilst that war is still going on. But by the time of his appeal, he explains, the civil war has finished, which enables the judge in his particular case to say, well, at that point in time that I make my decision, your country of origin, Sierra Leone, is now safe. How does the law deal with a moving situation like that, and is it a satisfactory state of affairs that we have?
It definitely is a fact. It has to be that that they are at risk at the time the decision is made, and I think that it worked not favourably for Mr. A, but in other clients' cases, you might think that sometimes the situation gets worse, and there might be developments within a country, or someone may be here and there'll be a complete change in regime and they have a surplus claim, and that needs to be able to be decided. So it does have to be protection, I think, at the point that the decision is made, and that's where the law lies, although it can be very difficult for people, especially when claims can take such a long time to be decided.
Yes.
I had a case very similar to Mr. A, which was a child soldier who came from Sierra Leone, and there's often, although the country situation changed, there's often things that you can still argue that someone needs protection in their particular circumstances, looking at their mental health or particular risk issues for that particular person. And in our case, we did ultimately get that client asylum, or protection or refugee status, even though the country situation as a whole had changed and was deemed safe. There were significant factors, and I think that always has to be looked at.
What about, Toufique, this idea of that you hear a lot in the media about passing through safe countries on your journey from your country of origin? What has been the law on that? What is the law on that?
Yeah, I mean, starting with the law first as it is, it's all about inadmissibility of claims and passing through safe countries. So that's all set out in either, and that it depends on when you arrive, whether it's the Nationality and Borders Act or more recently the Illegal Migration Act. And effectively, try and combine them both. Effectively, it says that if a person could have applied for asylum in a safe third country, or if they made an asylum claim in that country, or if they had a connection to that safe country such that they should have claimed there, then their claim for asylum here it would be made inadmissible. So they wouldn't even admit the claim to deal with it. It wouldn't be refused as such. It simply wouldn't be treated as an asylum claim. But there are good reasons why people do move through, and there are good reasons why people shouldn't be made inadmissible. For example, there may be strong family ties and connections in the UK. For example, if they're moving to the UK or moving onwards to the UK, there's law about coming directly in terms of the definition of that's set out in the Refugee Convention, and the case law, this is House of Lords case law, says that the mere fact that someone's stopped for a while in transit doesn't necessarily mean that they should be treated as being inadmissible because they were in a safe third country. I think most people do stay in France, actually, but those who don't, there are connections to the UK. So whether it's language, whether it's family, whether it's the in their mind a possibility that they will have a better life here, but also their treatment in France. If you look at the way in which, and not just in France, but through Europe, the way in which certain refugees and asylum seekers are treated throughout that journey is pretty horrific. I mean, they don't know what's awaiting for them in the UK, but there are good explanations as to why they continue their journey.
Am I right that when the UK remained a member of the EU, there was EU law, I think something called the Dublin Regulation, which allowed member states of the EU, essentially, in summary, to allocate between themselves numbers of migrants so that they could collectively try and deal with the issue of numbers. And now that the UK has left the EU, there's no longer that facility available to the EU. The UK can no doubt have its own laws, the sort you describe, but one of the consequences of leaving, might be thought an ironic consequence of Brexit, is that the UK is now outside of a club system which allows an allocation by agreement in principle.
Yeah, absolutely. I mean, that was kept very quiet by the Leave group, because what the Dublin Convention allowed for was a power to return people to the country that they had originally arrived in within the Dublin context. So people who had arrived and passed through or claimed asylum in places like Italy or France or Germany could easily be removed back to those places if they had got to the UK.
So Mr A's claim then fails, but he nevertheless remains in the UK. Let's hear from him now as to what happened after his claim failed.
I'm always in touch with them. I go there once a week, sometimes once a month, I've been signing on, but I never disappear from them. Never. I never do that. Because I know everything is genuine, so there's no, and if I run away, then how can I survive at the end, When they tell me we're gonna deport you, I still go. I still sign on. I don't get panic, It's because I'm already here. I just move with the flow. Whatever they say, come and sign on. I come and sign. Come to appointment. They told me go to Sierra Leone and busy. I went there. Everything they say I do, and so I just don't understand. It was just it's a frustrating time, So I was given permission to work, so I was still working until 2008-9 somewhere, and then they told me they changed my ARC card to say you cannot work anymore. So, and that gets it more tough for me, because now you can't work at all. You can't do nothing. So I have to depend on friends. And then luckily I met my partner, and she was the one support with food and everything up till today,
Roberta, we hear there about Mr A's change of circumstances. That particularly he talks about the fact that initially he was able to work, he had permission to work, and then that was revoked. So much of the discussion about asylum seeking and immigration generally is concerned with issues of employment and perhaps accommodation. What are perhaps the headline points about the differences between your rights when you're still seeking asylum on the one hand, and your rights if your claim to asylum ultimately fails?
The rights of people claiming asylum are very limited in terms of what they can do. In terms of permission to work, and whilst you're claiming asylum and that's pending, you can apply for the right to work after 12 months. So after you've been waiting for a decision for 12 months, and even then, if it's granted, it's only in very limited roles. So they have to be on what's the shortage occupation list, which is a list of occupations which there aren't that are deemed not to have be filled by the UK labour market. For those Otherwise, they can claim asylum support, so NAS support, if they've got nowhere to live, so no adequate accommodation available to them, or if there's no money available to them to support themselves, so they can either get financial support or financial and accommodation. If it's financial support, they get £49.18, I think it is, a week, or around that figure. Or if they're in accommodation which is catered, it's £8 a week, or just over £8 a week, so it's really not very much money that people kind of are left to survive on.
Is this after 12 months or within the
This
first
is the
12
beginning.
months?
No, you can get asylum support from the beginning if you make that application and you're deemed to meet it. But the work is after 12 months. Yep. Accommodation can be dispersed anywhere, so there's not a choice that I want to live in London, and you can be moved around the country. And of course, there's the big accommodation support or accommodation centres and the barges that we're seeing now that people are accommodated in. It's quite very difficult. If you're refused asylum, you've no longer got a right to work. So this is if your appeal right, you would do throughout an appeal and until your appeal right exhausted, but that ends at the point that you can't challenge any further. So you've got no right to work. You can apply for something called Section 4 support, which is very limited support. You could get accommodation and a kind of card called an Aspen card where they credit some money, but again it's limited. But that's only in certain circumstances. For example, if you've taken all reasonable steps to leave the UK, but there's something kind of preventing your removal, or if there are health complications, which means you can't leave at that time. Or, for example, if failure to give you that support would be in breach of your human rights. So if you've made a fresh claim for asylum and that's pending and you need some accommodation finances available to you, then you'd get that support then, but it is very limited.
That's your rights if you're here. I mean, people will say, thinking about Mr A's case, people will say, once he's had his asylum claim finally determined against him, he's somebody who should voluntarily remove himself to his country. I'm interested really in either of your perspectives as practitioners who've had so many clients, I'd imagine, in precisely that sort of situation. What's the reality there?
I would say it's not so easy. I think people claim asylum and seek protection because they firmly need it. Yeah. And then they need that protection, and suddenly you've got a judge who's decided that you don't qualify, and that can be really difficult. There can be many reasons why people don't leave. It may be that they make a further claim for asylum, so a fresh claim, and they have other evidence, or their mental health deteriorates such that there's medical reasons why they can't return because of the very fear of returning. It's so hard to deal with that consequence of the decision. Or it could also, people do build ties, over the time, especially when cases take many years to be decided. I've had clients who we challenged, and then the case was dismissed. But by that time, they were partners, children. It wasn't sufficient at the time of the appeal, but soon after, maybe they can make that application, and that is a reason to stay. So it's not a simple choice for people to leave.
Yeah, I think it's worth, just following on from what Roberta says, it's inbuilt within the immigration rules that you can apply effectively as a fresh claim for asylum. So it's within paragraph 353 of the immigration rules, where it does say that if you do have significantly different material that has previously not been considered, together with previously considered material, creates a realistic prospect of success, you have every right to make a fresh claim.
And you don't voluntarily remove yourself. The day may nevertheless arrive when you get your letter which seeks to enforce your removal, and you can make similar arguments at that stage, can you? What are the nature arguments you can make, and
so
where do you make them?
No, we've always been involved in cases where people have been about to be removed, and because normally you're detained before removal, you're able to see a lawyer effectively about your removal. But the reality is that you only have those last-minute claims, and you're only able to put forward last-minute representations precisely because they have not been made before, because of all the things I've said about the lack of access to justice, the lack of a properly prepared asylum claim. And really, it's only when you get to that last moment, and you may see another lawyer in the context of your removal, that you're able to put forward these claims. And again, the Home Office and the courts do provide and accept claims if they're meritorious, which would ultimately stop your removal.
Let me come back to that in a moment. In Mr A's case, no attempt was made to remove him initially for some time, but then he got into some trouble. Let's have a listen.
I get problem, then I went to prison. They gave me 1 year. I went to prison, and then Home Office detained me more than I supposed to spend 6 months in prison. I end up spending 16 months, 14 months in Belmarsh prison, and then 2 months in a Devon detention center. Before I came out in 2015, I win the case. I win the deportation case in 2015. And then when I came out, they appeal against it. They did it several times until the appeal turned down. So I have to look for money. I borrow money from friends, try to fight the case, and it's very difficult. And I don't have no money to, because was kind of private lawyer, and I can't have no money to continue to fight them again. So I have to end up relaxing. I just say I can't do this again. My own is to, when they tell me every month, come and sign on, I just get up and go and sign on. That's what I do. And then one day I went there in the 2017, and then they took me to Gatwick Detention Center. Basis on what? There's no any reason. I just was there for about I was there about 5 weeks, and then then they released me to come out again, and that's where Duncan Lewis came in to step in and support me, and I really appreciate the work they done for me. Yeah, I really feel much comfortable, and I'm still have to wait because the solicitors have to get certain things and get done, and then I keep moving forward. Yeah, my plan is to able to sort everything out and able to work and support my young family. That is the most important thing now.
Roberta, Mr. A mentions his family life there, and something particular happened in his case, namely that he committed a crime, and that engaged the law on deportation that we talked about before. Let's leave deportation aside for one moment and just assume one's in the position of somebody whose asylum claim has failed. They're liable to removal, but they've built up significant family ties. There'll be some perception that any sort of family tie will be sufficient to enable a failed asylum seeker to nevertheless resist their removal, the enforcement of their removal from the UK. What's the reality there? What sort of argument do they have to make? What sort of threshold do they have to satisfy in order to persuade the authorities or a judge that they can stay?
So you're looking really where there's married, that people have been in a relationship for 2 years, where there's children, that they're British, that they've lived here for 7 years, or that it would be unreasonable for them to leave the UK. When you're relying on relationships and kind of family life, you're looking at the obstacles for them to enjoy their relationship together abroad. So there's very significant obstacles for them to be able to kind of move back to the country that the person's from and enjoy that relationship. And it's really not straightforward at all. It's definitely not just simple to say, I've got a partner or I've got a child, I can stay.
Toufique, talk to me about a topic you mentioned earlier, which is detention pending removal. When in law does the Secretary of State have the power to detain someone pending deportation, and how long can they detain them for?
Yeah, so the rules actually were amended quite recently, again with the introduction of the Illegal Migration Act. So it's all connected to their removability. So you can't just arbitrarily detain someone for sort of endless amounts of time.
Well, because they don't have status.
Because they don't have status, or that because they've applied for asylum. They can only do so because if it's deemed reasonably necessary to remove them from the jurisdiction.
The basic theory presumably being that it may be necessary because otherwise they'd abscond, they'd seek to resist. Is that right? Is that the basic rationale behind the...
Not just that, but it gives the Secretary of State an opportunity, a reasonable period to document them,
Yep.
to establish that the receiving country will receive them, will allow for entry, but also, to ensure that the removal can take place.
Well, let's move on to recent events in Parliament. We record this just 2 days after the Safety of Rwanda bill was passed. We should first explain what it does. Toufique, let me start with you. Let's start perhaps with the previous policy. So before this legislation, in order to put it in context, the policy before this legislation, as it was successfully challenged principally by you in the Supreme Court. What was the story?
Priti Patel at the time announced this Rwanda scheme. Effectively, it meant that people who applied for asylum in the UK wouldn't have their asylum claims processed in the UK. They would effectively be offshored to Rwanda to have their claims processed there, and they would remain there.
Regardless of the outcome of the determination. Yeah.
Now, you can have opinions one way or the other as to whether or not that's sort of humane and morally sort of defensible in terms of transporting people to another jurisdiction. But what was problematic with Rwanda was that the Rwanda, their own human rights record and their own asylum processes, when we looked into it on behalf of our clients, and when the UNHCR chipped in with serious amount of evidence, all showed that there would be a real risk of ill treatment and potentially onward refoulement of those people if they were removed to Rwanda.
So just explain refoulement.
So refoulement is effectively returning someone to the country where they fear persecution. It could be a direct refoulement, or it could be effective constructive refoulement when they are just simply told to leave, and there's a risk that they would end up in their home country. And
this was just a policy, as it were, of the Secretary of State, just announced this is how we are going to treat this cohort of people. It didn't have a legislative basis. It's challenged on that basis through the courts and then all the way up to the Supreme Court, and the Supreme Court decided.
Yeah, and we were actually successful in the Court of Appeal.
Yep.
The Secretary of State appealed that decision, went to the Supreme Court, and the Supreme Court found in our favour. Effectively, they said that there were substantial grounds for believing that asylum seekers being sent to Rwanda would face a real risk of ill treatment as a result of the refoulement to their country of origin. There are other issues as well as to the processes in Rwanda, the fact that there wasn't a proper asylum system, that they couldn't handle and properly consider the asylum cases, which would then have led to basically erroneous decision-making, refusals possibly, which would have potentially led to that refoulement.
So by implementing that policy, the United Kingdom would be in breach of international obligations that it owed people to avoid refoulement by sending people to Rwanda. All right, so the reaction to that then, Roberta, is this legislation that's just been passed.
Yes.
The risk of asking a difficult question to summarise. It's a pretty unusual, I think it's fair to say, piece of legislation, whatever one makes of it. What does this new legislation do or seek to do?
It's a statutory declaration that Rwanda is safe, notwithstanding, as Toufique saying just 3 months ago, the Supreme Court found quite the opposite, and it binds all decision makers, courts and tribunals to find that it's safe, notwithstanding any provisions in domestic law or their international law obligations or Human Rights Act, which may find otherwise. It significantly restricts individual rights to challenge that decision, to find that finding that it's not safe, or to challenge their removal. The court can only grant relief in very exceptional circumstances where there's very real risk of foreseeable, serious, irreversible harm if they're removed to Rwanda, and it's very, very limited. If the individual applies to the European Court of Human Rights, then they make an interim measure, then it's for the government ministers and not courts to decide whether to comply with that.
Because this is what had happened first time round, right? That those seeking to injunct, in other words, to stop, at least for the time being, flights taking off under the Priti Patel policy as originally announced, went all the way to the Strasbourg Court, the European Court of Human Rights, who issued a decision saying that at least until the UK courts have looked at the problem, those flights can't leave the ground. One of the things that this new bill tries to do is to stop somebody from going along to court to get what's called an interim injunction in order to even make that argument in the UK courts. Lawyers, no doubt, looking over the maybe one of them is in this room, Toufique, looking at the legislation pretty closely to see whether there's some angles that can be deployed to try and do this.
I think it's worth mentioning when we got that Rule 39 interim measure effective on the day of the flight, which at that time, it seems a long time ago, but at the time the government policy, you'd think reasonably, was to abide by a Rule 39 because they accepted that that formed part of international law. But what this legislation does is it gives the Minister of the Crown the decision-making, the power to ignore it. Now, we will, as lawyers representing clients who are potentially liable for the next flight, pursue every avenue possible, including getting another interim measure. Now, it's obviously then for the Minister of the Crown to decide whether or not they ignore it, and then we'll have to decide whether or not we can challenge that decision. That's one aspect of our challenges, and there are many other issues and many other areas that we're looking at now the bill has passed, to see whether there are potential challenges to primary legislation, which any public lawyer will know is difficult, but also through the very limited powers this Act gives to individuals to challenge their removal. We're looking at those features. All
right, well, we'll have to wait and see. Roberta, Haslam and Toufique Hossain, thank you very much for cross-examining with me today.
Thank you very much.
Thank you.
Well, we've reached the end of the podcast, but we'll be back soon and we'd love to know what you'd like us to examine next. Tell us what you're interested in or concerned about in the world of law by tweeting at CrossExaminePod or by visiting our website. That's www.crossexamination.co.uk. Remember to follow us wherever you get your podcasts. And if you've got time, we'd love a positive review on Apple Podcasts. It's the best way to spread the word about cross-examination. Meanwhile, I've been Tom Cross, and until next time, goodbye.